Okay, is this better? I hope this is better. Hopefully you can hear me. Is this better? Let me know. Let me know if this is better. I'm back. I'm back. I'm back. I'm back. Is this better? Can you hear me? I hope you can hear me because earlier there was commentating, which I appreciate, that says you cannot hear me. Let me know if you can hear me because I don't want to start and then it be going out. Can you hear? Can you hear? Let me know if you can hear. Type in the comments. Let me know. So far, so good. Thank you, Andrea. I appreciate it. All right. Thank you, Warren. I appreciate it. All right. So let me start again. I am Natasha Robinson, and in addition to be a licensed but retired criminal defense attorney, I am a criminal justice professor, for those who don't know. So I say that to say these comments that I am saying are not because I don't have anything else to do or because I don't know what I'm talking about. I try to comment on legal cases, legal news, legal commentary that I hear, and I try to break it down because when we are watching all of this commentary on television, there is no question and answer period for those who are watching. And so I'm here to tell you that even the media gets things wrong. What's the first thing that they got wrong today? Some media persons, some journalists in the media realm refers to this trial that is going on regarding the murder of George Floyd as the criminal trial of George Floyd, as if George Floyd is on trial for his own murder. Now, please be clear, that cannot happen. And so when we're talking about this trial, language matters. And let's characterize it for what it is. This is the Derek Chauvin or Chauvin. I don't really care how you call his name. This is his criminal trial because he is on trial for killing, for murdering George Floyd, not George Floyd trial. So please, if you hear somebody saying it, or if you yourself are saying it, stop because that's wrong. Um, and I say that in love. The other thing is that I was saying I saw on someone's social media page when someone was saying, okay, it is the Derek Chauvin trial, it is not the George Floyd trial. Someone fixed their mouth and their fingers to say, I kind of like it when they call it the George Floyd trial. Say his name. No, that's not how that works for a number of reasons. One, that is legally incongruent because the victim of murder cannot be on trial for his own murder. That's the first thing. The second thing is that how are you going to honor this man by putting him on trial and shifting the blame and saying that he is responsible for his own death, which incidentally, that's what the defense is going to argue. How are we as the public going to honor George Floyd, not just in a hashtag, not just in painting roads and streets Black Lives Matter, but engaging in policies, engaging in accountability holding for those that feel that they can take a civilian who is under arrest and handcuff and do anything that they want to do without any type of consequence, without any type of punishment, without any type of accountability. That's how you honor persons like that. Not by saying, oh, it's this George Floyd trial, like we on some game show or something. No, it doesn't work like that. Okay. That's the first thing. The second thing is by this being the first day of the Derek Chauvin trial, you can start practicing if you've been saying George Floyd. You can start practicing now so that when you engage in conversation, you know what to say and how to say it. Okay. Because basically, in my opinion, when you say the George Floyd trial, you're killing them twice. And that is ridiculous, and it's absurd, and it's offensive. So anyway, point number 2. In the trial, the first day, we had opening arguments, which in some jurisdictions called opening statements, and you have it from both the prosecutor and the defense. Understand that opening arguments are not considered to be evidence. They are to a criminal trial what a trailer is to a movie. You know how when we are waiting for a movie to come out and there is a trailer that says, okay, these are the coming attractions. They show you just a little bit, but they don't show you everything because they kind of want to pull you in. That is the same thing with opening arguments. Opening arguments, the commentating by the prosecution and the defense, that is not considered evidence. Okay, that is a trailer where the attorneys are telling the jury, and basically the jury that is not in the courtroom, which is the world, the attorneys are telling the jury what they think the evidence is going to show. And why do they say what they think the evidence is going to show? Because they don't know. They have no clue until they are actually in real time presenting testimonial evidence, which is what a person is testifying to under oath. Physical evidence, which is what you can touch, the tangible. So, like a cell phone or I don't know, a murder weapon or something like that. That's tangible evidence. Okay. And then you have exhibits. What are exhibits? Exhibits are the type of pieces of information that the attorneys can rely upon to help the fact finder, in this case, the jury, better understand what this case is about. And so when you had the opening statements of the opening arguments, you had the playing of the video, which I knew was going to be played. Why? Because what you're trying to do is you're trying to start the trial off right with the emotions that the world felt when they saw this officer sitting on top of a person who was handcuffed and who said repeatedly, "I cannot breathe." All right. So that is emotion. Please understand that emotion cannot be substituted for evidence. How many times have we reacted to something that we've seen and the jury come back with some type of verdict where it was like, are we watching the same shit? Did we look at the same thing? And this is how I explain it to my students, is that if I said to them, I was driving down the street in a red car, I assure you their red is going to be completely different than my red, because our perceptions are funneled by our experiences. So when you then bring those experiences to a set of facts or evidence, you may look at something completely different than what we look at. So when the prosecution was doing its opening statement, remember, it's about pulling out the evidence and all that. I mean, pulling out the emotion, but this is not evidence. The video has not been moved into evidence yet. And I can assure you that the defense is going to object, because the defense, the attorney for Derek Chauvin, is going to say the legal words are, it's more prejudicial than probative, which means this video that is being shown is going to be more prejudicial against Derek Chauvin than it is as to the probing factor of whether or not Derek Chauvin killed George Floyd. Now, let me park here and explain to you that just because you see something factually does not mean it has the same weight or admissibility legally. We all saw Derek Chauvin sitting on top of George Floyd, and George Floyd eventually dying. Okay? However, what we see factually does not automatically mean that it is going to be legally admissible. And if it is admissible, it does not mean that it is going to carry automatic weight. So, for example, if I say that this is the gun that I saw that was held to my face, and my arrest went viral. Just because it went viral does not mean that the video or the gun automatically comes into evidence. There are rules of evidence that have to be followed. And I assure you, there are going to be some arguments from the defense and from the prosecution that is going to affect the admissibility and the weight that is given to the evidence that is submitted. So once you had the prosecution do the opening argument, and then you had the defense do their open argument, remember, this is not evidence. This is just commenting on what they think is going to be evidence, because the judge has not ruled on the admissibility of it yet. So then you have the prosecutor questioning what I believe is its first witness. Let me tell you something about witnesses. Anyone who has ever questioned a witness will tell you that you can't ever predict what they're going to say or what they are going to do. When I was practicing, the statement was, you take your witnesses as you find them, which means you're trying to elicit the most information from that witness. If they are your witness, if you're calling them as your witness, you try to elicit as much information from that witness as you can to strengthen your side of the case. And so there are a myriad of reasons why this witness did not come off well. She could have been nervous because this is, a worldwide trial that is easily accessible and watched by millions. Okay. She may have been nervous. And even the trials that are not televised, a witness can still be very nervous, no matter how many times you prep them. I can tell you from experience, I have testified only once as a witness, and my nerves were out of control because I wanted to make sure I sounded right. I wanted to make sure I was believed. I wanted to, remember, what I was testifying to, because everything that is testified to is also typed down by the court reporter. In the event that there is a question, or in the event that there is an appeal, or there is a huge reliance on the court transcript. So she could have been very nervous. The other thing is, the prosecution could have been very perfunctory in its duties. And what do I mean by that? Sometimes people just do stuff to do stuff without really being invested in the outcome. Maybe this prosecutor didn't prep her well. We have been taught, when I was in law school, and particularly when I was in the public defender's office, we were taught that you don't ask a question to which you don't know the answer. And I have been slaughtered when I have asked that, what we call that one question too many, where you ask a question that you have not gone over with the witness. And when I say go over the witness, I'm not saying feed them like a puppet. What I am saying is, because, and you're right, April, testifying is terrifying. So what you try to do is you try to tell the witness, whoever is testifying on your behalf, this is the goal, okay? The goal is either to have your testimony show that a person is guilty or show that they are not guilty. And it's been my experience, if I say to the witness, this is what the goal is, then they can kind of remember that, because they don't remember everything that they've already said. The other thing you need to remember is that there is a period of time between when a person talks to someone and their testimony or their statement is recorded and when they testify. For a murder trial to occur in a year, let me tell you, from here in Cook County, that's quick. Because most murder trials, it's about 4 or 5 years later, and the person may not remember what they have said. Even if you are reading to them, No, boo, this is what you said on December 7th, 2019. And it's now, December 2021. So that could be a reason, is maybe she was not prepped, maybe she was terrified, maybe she didn't remember. uh the one of the number one fears for people is still public speaking. And so when you are public speaking to millions, that could be terrifying. Okay. Now, am I excusing away her performance or the prosecutor's performance? No, I'm just simply saying, think about it in a different way, where you have just, the most you have ever done in terms of public speaking is giving an Easter speech or giving a class presentation. For some, we can do it, ain't no problem. I'm one of those people. You put me in a room of room of 2,500, 3,000 people, I'll be nervous, but I can do it. But for some people, even talking to more than one person is terrifying. And so what happens is that when someone is nervous or scared, that gets misinterpreted as they cannot be believed, at least in my experience. Okay, Najee, in your professional opinion, do you believe the video will be able to be admissible into evidence? I believe that part of the video will be. I don't think that the video in its entirety. And the reason why I'm going to go with that is because when you watch the entire video, at least for me, it is an outrage and it is hard to watch. And so I think that the defense attorney would say, okay, we can watch to the point of when, George Floyd loses consciousness, but anything other than that, they're going to say it's pulling on emotion. So I think it'll be entered into evidence, but I don't think the totality of the video will be entered in evidence. All right. So I'm trying to think if there's anything. Are there any questions that you all have that you can ask me? I'll be happy to answer. I'm sorry for the earlier technical difficulties, because trying to find my computer and make sure I'm heard, that kind of, threw off my train of thought. So I want to make sure I did not miss anything that you had to ask. But in terms of day one, opening arguments, opening statements, they're not evidence. They are just predictions of what they think the evidence is going to show. That's the first thing. The second thing is that this is not the George Floyd trial. This is the Derek Chauvin trial. So let's clean up that language. Avery said, cops are professional witnesses, other folks are not. We place unrealistic expectations of regular folks to be orders when they hit the stand. Absolutely. And April is, in my opinion, one of the top criminal defense attorneys and civil rights attorneys in the country. She can tell you, I can tell you, is that when we have these type of public trials, somehow there is supposed to be some type of metamorphosis of regular folks, that now they're supposed to be perfect in their diction, in their language. I seem to remember when the trial of now I can't think of his name, but he killed Trayvon Martin. I remember that there was a line of conversation that was talking about how a witness was talking. And based upon how that witness was talking, it was misinterpreted as they couldn't be believed. It's these type of biases that prevent people from getting to the truth. If I am not able to articulate what I saw in a perfect way, does that make me unbelievable? For some people, the answer is yes. Yes, George Zimmerman. Okay. In the trial of George Zimmerman, not Trayvon Martin. In the trial of George Zimmerman, one of the witnesses, I believe, was a friend of Trayvon's and was very nervous, and there was some type of speech barrier that he was unable to break through. And so there were those that said, okay, well, he helped the defense win. And that is not true. That, to me, that is not true. There are, as I said again, you take witnesses as you find them. And so if this young lady who was working at the gas station is not a person who is a great public orator, or she's nervous, or she thinks that because I'm testifying, something is now going to happen to me because the world knows me and my name, that will make anybody nervous. That would make anybody nervous. Jay, you said, what justifies a charge of murder 2 instead of 1, if not already answered? I have not answered it, but I'm glad you asked me. In general, first degree murder is involving some type of intentionality. Where if you are charged with first degree murder, the premise is that you intended that person to die. It sometimes can be premeditated, and sometimes it's just, I just intended for that to happen. That's first degree murder. What excuse me, what Derek Chauvin is charged with lacks intention. So let's be clear. All of the charges that he is facing, none of the Minnesota statutes say in the language that it was intentional or that it was purposeful. If anything, it's in layman's terms, I say he's charged with, he should have known better. That's in my opinion, that's what he charged with. He should have known better. As opposed to he knew better and intended for George Floyd to die. Now, where the defense is going to come in is the defense is going to say that there were intervening causes that led to George Floyd's ultimate death. And they're going to argue that Derek Chauvin was just but one factor that led to George Floyd's death. They're going to talk about the toxicology report. You're going to hear that through the medical examiner, because anytime there is a death, the medical examiner or the coroner will do a autopsy, and they do an external examination and they do an internal investigation. And so they will talk about, any, if it's a murder by a firearm, they will talk about how there are exit wounds or entry wounds. They will talk about the cause of death and the manner of death. And so in this trial, they are going to talk about George Floyd's toxicology report. They're going to say that he ingested some type of substance, alcohol or drugs, and that was the reason for his, wait for it, aggression. That was the reason why he was acting as an animal. That is the reason why Derek Chauvin is justified in doing what he did. Okay, so they're going to talk about that. And they're going to also talk about his health. They're going to say, I think it was one of the first responders that may testify and say that George Floyd's blood pressure was too high, and that he was already at risk of death or severe injury before Derek Chauvin even came onto the scene. You said, so Minnesota law says it was okay to keep his knees on him with cuffs on. That factor hurried his death. Now, it depends. The jury is going to have to say that in order for Derek Chauvin to be guilty, he has to be reckless and the direct cause, or at least one of the main causes for George Floyd's death. Now, remember, he's not charged with intention. He's not charged with first degree murder. He's not charged with the crime that says he intended or he was purposeful in doing X, Y, and Z. What he is charged with is recklessness, really, or that he should have been a little bit more careful. Okay, or that, and I did a live about this a couple weeks ago, but I don't remember. But it's the Minnesota law that talks about his performance in public, or something like that. So while he is looking at time, he is not looking at the charges, which, again, factual evidence would lead us to believe. Well, I don't even know why we having a trial. Okay. But remember, factual evidence and legal evidence are completely different things. We all know that Derek Chauvin killed George Floyd. But the legal question is he legally responsible and accountable for George Floyd's death? That is different than a factual question. And can the prosecution prove that responsibility or accountability beyond a reasonable doubt, which is the highest evidentiary burden that one has to prove a person guilty of, because that is how our criminal legal system is set up. They brought it up today. They say fentanyl and methadone. Yes. Okay. So methadone, if I remember correctly, is what is a type of drug that a person gets to wean them off of something. And I'm just going off the top of my head based on my memory, based on when I represented parents who face civil allegations of abuse and neglect of their children. When they had a type of drug addiction, they would get methadone, and methadone is what would kind of uh, uh, pull them off of so the addiction wouldn't be as severe. Okay. um, and so again, this is nothing more than victim blaming and blame shifting. Okay, which is why they're calling it the trial of George Floyd. uh, I find it to be completely absurd that not only am I killed, but now I'm being tried for my murder, because I was the reason why I was killed in broad daylight in front of many people who were telling my killer, "You're killing him." Okay, so that's on that. So it is still going to be a while evidence is unfolding. Um, I just want you to be mindful of the fact that, again, just because factually Derek Chauvin killed George Floyd does not automatically lead to legal accountability, even if the evidence is there. All right. And so it's still too early to tell what is going to happen. But all we have to do is decide whether or not we're going to watch. But as I said earlier, I will not rewatch that. I will not rewatch that video. So what y'all talking about over here about methadone and methamphetamine? Like I said, I'm not a doctor. When I used to represent parents who were facing civil allegations of abuse and neglect, I remember um, oh, it's not methadone. Okay. Methamphetamine. That's completely different. Thank you, April. That's completely different. A methamphetamine is completely different from methadone. Okay. So they say fentanyl and methamphetamine. Okay. All right. That's completely different. So somehow the defense is going to say, because of the ingestion of these drugs, that is the cause for why he died. And Derek Chauvin putting his knees on his neck and his whole body weight, that is an aside. That's what brought him into court, Derek Chauvin, but that's not the reason why, or not the sole reason why George Floyd died. Okay. And like I said, I've seen way more evidence, and there be not even an acquittal, there's not even an indictment. Okay? Think about Eric Gardner. We saw multiple New York police officers kill him in a chokehold that was outlawed by the New York Police Department. And what happened? Were there even any charges brought against these police officers? No, there were not. So that is my exhibit A of saying that just because we see something factually does not mean it will have the predicted legal outcome we think it's going to have. All right. So just be mindful of that. Other than that, I think that is it. Just understand that it is the prosecution who has to prove him guilty. I'm not surprised. In April, you can tell me or not. I'm not surprised by the fact that they did not bring in special counsel to try this case, because I think personally it's a conflict of interest to try a police officer who usually is your witness, is your informant, is the person upon which you rely when you're trying to prosecute someone. And so I don't think they brought in a special prosecutor. I think I don't know who these people are. I would have to sit and do and do research. I don't know who they are off the top of my head, but yeah, that's what's going on so far. So I think that it's too early to say which side is winning or what's the outcome going to be. I can clearly go with my gut, but I'm going to wait and see the evidence bear out and see what's going to happen. But that is pretty much my analysis of day one so far. Day two is tomorrow, and I'll come back on after the little one is asleep and just break that down for you. But that's pretty much it. Any other questions you have, you can put it in the comments in the chat. But for now, that's it. So thank you for providing the information where I have gotten it wrong or where I didn't know the information. And we're just going to stay tuned. All right. You all have a good night and be safe. Bye-bye.